The Constitutional Court will no longer enlist the services of retired justices to assist with the applications for leave to appeal as part of addressing the backlog in the country's apex court. Instead, it could employ experienced lawyers to provide support to the justices of the Constitutional Court, including the preparation of a memoranda in new applications. However, the Office of the Chief Justice maintained that Justice Zak Yacoob, as well as retired Justice Johan Froneman, would be volunteering their services and would not take part in adjudicating of any matters. Let's now unpack this decision. We now speak to Alison Tilley, who is the coordinator from Judges Matter. Alison, good morning. Thank you so much for making time for us. So there was a lot of protest against this particular decision. Also, some people arguing that essentially what the Chief Justice would be doing is extending the term of some of the retired justices, knowing very well that the legislation says 12 years and no more. What do you make of this decision that has been taken now?
Well, I think it's the right decision. The Constitutional Court is a very particular court. It's different to our other courts. And one of the reasons it's different is exactly because it's what we call the apex court, so the court that sits at the top of the whole system. And we have a very particular selection process for judges that sit on that court. It's different from other judges. And the reason it's different is because this court gets to have the final say in all matters, but particularly in constitutional matters and reading of the Constitution. So we have this very thorough, careful process for appointing people. It really then does follow that the people who are sitting in that court and making those decisions should be the people who are appointed as Constitutional Court judges and are currently sitting or acting.
Yeah. So this is the suggestion that is made as to how to resolve the problem going forward. The Chief Justice and his colleagues propose that two measures need to be pursued. The one is that experienced lawyers should be employed to provide support to the justices of the Constitutional Court, including the preparation of memoranda, as we just said in our introduction. Those experienced lawyers will have to be in addition to law clerks. So how is this then different to the argument that you make now, that when it comes to the judges, there is a thorough process leading up to the appointment of the justices, but with this one, the appointment of experienced lawyers, surely they won't be going through that same rigorous process around the appointment of justices?
No, you're exactly right. And I think that's why exactly the role that is going to be played by these people, no matter how experienced, will have to be very carefully navigated. I mean, we know that certainly for the judges Yacoob and I think it was Froneman, yeah. That it was inappropriate for them to be making decisions around appeals. And the thing with the memorandum, I'm not sure people always understand why that's so important. If you look at the very first framing of an issue, where you start explaining, why these particular facts lead to this particular conclusion in law, it really does shape the way that you look at the issue and how you think about it. And it's super important that, who does that is a ConCourt judge. I think what we know is that the court is under a lot of pressure. I think we know that the decision to make it the apex court in all matters, maybe that wasn't the best idea. And now we're looking at the consequences. There's a good reason to increase the number of staff. There's a good reason to boost research capacity. But really what you want to be doing is making sure that the people who are making the critical decisions around who is going to be allowed to appeal to the court, and then also how the issue should be framed, that really is something that the ConCourt justices need to do.
Yep. What do you make of the proposal of perhaps maybe that the Constitution then should be amended?
I'm not sure how the Constitution being amended would assist. I'm not sure that I understand the question.
Sure. Okay, so in the statement that was released by the Office of the Chief Justice, this is what they say. The other is that the Constitution should be amended to make it possible for the justices of the Constitutional Court not to sit in bank when deciding new applications, but to form panels of 3 to decide new applications.
Yeah, I mean, I think that's probably a good idea. The difficulty with the court at the moment is that it's still missing people on the court, and if the court moved more quickly to make sure that people are appointed to the court, then at least you'd have your full panel. We know that there's going to be a round of interviews in April, so that will help with adding to the number of people on the court who should be there. So I think that would also assist. And of course the idea of panels looking at this issue, I think, is also a good one.
Yeah. You just made reference now to that decision to allow for the extension of the jurisdiction of the Constitutional Court, in hindsight perhaps, that it wasn't the right decision. However, though, the emphasis there was that also related to matters of public importance and public interest. If there is a review of that particular aspect in relation to, sure, maybe a constitutional question doesn't arise from the application that has been brought, but there is a public interest and public imperative that the Constitutional Court should hear that matter. What happens to those particular cases, do you think?
Well, I think the way that it was really looked at previously was that the Supreme Court of Appeal would look at those issues. It's a very important court. It's really has some of the most senior lawyers in the country sitting on that court, and there certainly might well be benefit in them being able to deal with matters and resolve them, unless there is a constitutional issue, directly a constitutional issue. And then that goes to the Constitutional Court. So a public interest test, every case is important and of interest to the member of the public who that case involves. But what we're really looking for are questions around constitutional interpretation and the development of the law. You've got to remember that one of the important things that judges are supposed to do is look at things like the common law statute and make sure that it is developed in line with the Constitution. And that's a pretty big job in and of itself. Yeah.
What about extending the panel of justices now for the Constitutional Court, and something similar, for instance, that we have with the Supreme Court of Appeal, where you don't have the same justices overseeing or presiding over a case? So there is that rotation that happens. Could that assist in any way?
I think your difficulty is that if my theory is correct, and that it should be the important constitutional cases that go to the court, there's a reason there are 11 justices. It's because these cases are complicated, difficult, and if you have that panel of judges, you have the important diversity that panel brings. So diversity along the lines that we usually think about, but also diversity in terms of background, specialization, whether they practiced, where they practiced. All of these things will make a difference in how judges will approach a matter. And it's super important that we hear all of those different kinds of lawyers on constitutional court matters.
Yeah. Just in conclusion, Alison, following that decision that was announced by the Chief Justice last year to allow for academics to also form part of the panel of justices, and also looking at the Supreme Court of Appeal, one of the cases actually yesterday before the Electoral Court, we had a professor that was also sitting as part of that panel. Do you think that we have now felt the impact of that decision?
Well, I think that's going to be a very big part of developing the court's jurisprudence. It's something that we've noted for a number of years that there really have been no academics appointed in acting positions, or perhaps none is an exaggeration, but very, very few. And I think this will give impetus to the idea that, particularly on the Constitutional Court, that an actual background in constitutional law as an expert on constitutional law is a really good idea, and again will provide that kind of diversity and range that the court really needs in wrestling with the issues that it does.
Thank you so much for your time. That is Alison Tilley, Coordinator for Judges Matter.